If you want to go forward, then you would look at when to file the patent application. Now, the patent application, the timing of filing the patent application is critical, because all countries like India now follow the first to file principle. The United States till recently had the first to invent principle, in the sense that a person who invents first gets the patent, even if he is late in filing the patent before the patent office. Now, globally, we have one standard, which is the first to file principle, in the sense that regardless of who invented a patent or who came up with the invention, regardless of who came up with the invention for the first time, it is the person who approaches the patent office first by filing an application who will get the patent. So, what the law has set, it has set a race to the patent office. It doesn't matter whether you invent first. What matters is the person who filed the patent application first. Now, there is quite a lot of history as to why we settled on this type of determining who came first, because inventorship disputes are tricky. It's very hard to establish. We'll have to get into lab records, we'll have to get back to how people kept logs on the work they did. There's quite a lot of effort that goes into determining who had actually invented it. And there are cases where two people or two teams of people may come up and say that we invented the invention around the same time. So it becomes very hard to determine who actually was the first inventor, because the patent is a game where there can be only one winner. If there is an invention, even if 10 teams work on the same invention, there can be only one winner, the person who completes it first. And the way in which the patent system determines who completes the invention first is by ensuring who approaches the patent office first. So this is called the first to file principle. The first to file principle tells us that regardless of who invents the invention first, it is the person who first files the patent application in the patent office who will get the grant in his or her name. Now, this also explains the way in which patents are now dealt with. There is an urgency to file a patent because now the world moves on the first to file principle. So you can't be happy or rest assured thinking that you are the first inventor and you can prove it in a court of law. Those days are now gone. The only way you can prove that you are the true and first inventor, that's a phrase which the Patent Act uses, is to show that you approach the patent office first. So the urgency that we normally find in filing patents largely is tied to this principle, the first to file principle. Secondly, the urgency in filing patents is also contributed by the fact that if you don't file, somebody else will file and claim priority. Now, priority simply means who approached the patent office first by filing a document. So, priority is important for us to understand whether your patent merits, to understand whether your invention merits a patent. The day on which you file an application for a patent, if there is a prior invention disclosed in the prior art, then you don't claim the priority because somebody else has preceded you to it and has already filed an invention or has claimed it. So if somebody else has already claimed an invention, then you will not get it. So priority is important when you follow a first to file principle, because you have people approaching the patent office and filing applications all the time. Now, if there is a dispute with regard to who filed an invention or who claims a invention, then we'll have to look at the principle of priority. Priority simply says the point at which you made a full disclosure of your invention. Now, there are inventions which can be disclosed in parts. Assume that there is an invention with 3 critical components. You make a disclosure of the component number 1 in, say, in March of a particular year. Component number 2 is disclosed in April of the same year, and component number 3 is disclosed in May of the same year. So March, April, May, you make 3 disclosures. Only when you disclosed the component number 3 in May did you make a full disclosure of your invention. Till such time it was just a partial disclosure. So the law will treat the point at which you made the full disclosure, which was in May, as the date of your priority. So we have quite a lot of principles that govern how priority is done, but you need to bear this in mind. Priority is tied to the disclosure. The day on you make a disclosure of your invention, your priority will start. So first, we have the reason why people rush to the patent office to file patents is because we follow a first to file principle, which is tied to priority. 2, the danger of others filing a patent and stopping you. So this is a legitimate reason why people file patents, because they don't want to be stopped from involving or engaging in the activities that they pursue because somebody else has preceded them in filing a patent, and if they get a patent granted, then they will be able to stop the activities. Now look at the investment analogy. If you are the head of an R&D department which has to invest quite a lot of money in a production line, now you have to ensure that the line in which you are investing money remains a clear line for years to come. It cannot be that you invest money, set up a particular assembly line for producing something, and find that down the line there is somebody who has patented that product and they have filed a case to stop you. So one of the things that you will ensure is to clear the way for your products to come out in the future. So in that sense, patenting is an investment, because though you file the patent, the benefits that accrue from the patents happen at a point later in time. So coming back to the when principle. Now, when you file is largely determined by the laws of the place that you operate, and it is also a call an inventor has to take. Normally, if the inventor has not come up with the full formed invention, there is a prospect, there is a promise, but the inventor has not really thrashed out the details of his invention. The law allows such an inventor to file what we call a provisional application. A provisional application can be filed, what we call a provisional specification can be filed, and later on, within a period of 1 year, when the details of the invention, when the inventor has more details about the invention, say he has done more experiments or he has done more work and improved it, then he can follow it up with what we call a complete specification. So the time of filing can be determined by the rate at which you are progressing in your work. Sometimes it could be a bright development or a promising development that you notice in your lab, and you may have to quickly work to ensure that you reach a point where you can make a disclosure. Again, the provisional has to have a disclosure which can cover the entire invention that you have come up with. Because if the provisional only makes a partial disclosure, and later on after a year when you have to file the complete, you make the remainder of the disclosure, there will always be a doubt as to when your invention was fully disclosed because of the partial nature of the disclosure. So one advice or a rule to follow is that when you are confident that the entire disclosure can be captured in writing, that is the time to go for a provisional. You will still have 1 year to come up with claims, to clear out certain aspects of your invention, and to explain the invention in detail. So, the call of when to file is something that is based on the preparedness of the inventor, to what extent the inventor has done work, and whether he can make a full disclosure. Now, apart from this, the inventor also has to decide whether to file an Indian application or a foreign application. Now, in India, if the inventor resides in India, then the default option is to file an Indian application, even if the inventor plans to take the invention to foreign countries. So there is a mechanism by which there are two mechanisms, in fact, by which after filing an Indian application, you can follow it up within a period, usually 12 months, by filing what we call a convention application. This is an international treaty called the Paris Convention, which we had already covered in our earlier lectures. So the Paris Convention allows you to follow up an Indian application with a foreign application in any of the countries which are signatories to the Paris Convention. So this is one route. If you don't want to take the Paris Convention route, or rather if you want to enter multiple countries, not just one country, then you would follow the PCT route, which stands for Patent Cooperation Treaty. Now, Patent Cooperation Treaty is a mechanism by which you can file an application in India and follow it up with a PCT application, because India is an office that receives PCT application, and then enter different jurisdictions based on your need within 30 months from the date of filing the application or your priority date. So you have a 30-month period to enter different countries. So the when to file an application will depend on whether it has to be an Indian application alone, or whether the inventor plans to file applications around the world, what we call foreign application, and whether being a resident, there is also an option of being a resident in India and filing an application in a foreign country. Now, this option can be exercised by getting what is called a foreign filing license. So this is something which inventors need to bear note. This is something which inventors need to take note of. Many a times, if you are collaborating with a foreign partner and you have a joint venture agreement or a memorandum of understanding to collaborate and even to file patents jointly, if your collaborator, say in the United States, files a patent there and shows you as an inventor and as a co-applicant, then you may be violating a provision of the Indian Act which requires the Indian resident, a person who is resident in India, to either file the application first in India or to seek permission to file foreign applications. So the permission to file foreign application is a requirement under the Indian law, and it has to be satisfied, especially in cases where you have joint venture partnerships with foreign entities, because the foreign entities will proceed and file a patent in their country showing you as a co-applicant without seeking the necessary permission from the Indian Patent Office. And you can't blame your foreign partner for this, because this is a requirement in Indian law. So if you have to file an application, either you by yourself or through your foreign partner, ensure that if you are a resident in India and the invention was made in India or part of it was developed in India, then you need to get a permission before you file a foreign application. You can always file an Indian application first and follow it up with a foreign application, then the permission is not required. But if you are not going to file an application first in India, you have to ensure that the required permission is obtained from the Indian Patent Office, even if the entire filing is done on your behalf by your foreign partner. Now, where to file the application? Now, the way to file the application is not a problem that is difficult to solve, because most countries require a residency requirement. However, most countries have a residency requirement. If you are a resident of a country, then, and if you have come up with an invention, the law will require you to file it in that country first. And if you want to file it in another country, as we just mentioned, you may have to go through a process of getting an approval from your local patent office. So the call on where to file is kind of addressed by the Indian Act, which says that if you are a resident and if you have invented something, you have to file it in India. That's a default option. But an option is given for you for whatever reason if you want to file an application in a foreign country to seek permission. If you want to file in a foreign country first. Now, there could be some inventions developed by inventors in India which may not have a market in India at all. Say the United States may be the primary and probably the only market. In such cases, it does not make any sense to file an application in India, prosecute it, get it granted, keep it alive by paying fees. In such cases, you can get a foreign filing license from the Indian Patent Office, and based on the license, you can file an application in a foreign country. Now, we had already mentioned this. You can file if you are interested in protecting your invention in more than one country, say 2 or more countries. Then you can file a convention application under the Paris Convention, or a PCT application, a Patent Cooperation Treaty application, which is managed by another international organization called the WIPO, WIPO, which stands for World Intellectual Property Organization. Now, if you are making multiple filings across the globe, one thing you will ensure is that you don't publish the invention before filing the first application. Once you file a first application, you preserve the priority. That application you file first preserves the priority for you, and based on that, you can disclose the invention in multiple applications. The law allows you to disclose it after you have published your application. So, law allows you to disclose your invention after you have filed an application. So, filing a patent application is important for you to preserve the priority. So, what happens if you first publish and then file patent applications? Now, your publication could be used by the patent office to state that your invention lacks novelty. Now, you may be wondering, the publication is mine and the application is also mine. Why should my own publication be used to kill the novelty of an invention? Because I made the publication and I filed the application. The law is the same here across the globe, that a person who seeks a patent should maintain secrecy about his invention till the invention is filed in the form of a patent application. This secrecy has to be maintained by the applicant himself. And if the applicant files or publishes the information before filing the patent, then it is assumed that the inventor has allowed the information with regard to the invention to come into the public domain. And what is in the public domain can be used to kill the novelty of any patent application. So, care has to be taken in not publishing the information about the invention before filing the patent application. Now, how do you file a patent application? Now, patent application has a series of forms. There are fees that accompany each of those forms. You normally file a patent application by drafting a complete specification. A complete specification, there are parts to a complete specification. It is a techno-legal document in the sense that it captures the technology and the history of the technology and the development of the technology about the invention, but it is worded like a legal document because unlike a scientific journal article where you make a claim or where you make a discovery and inform the world about working of a technology or a product, unlike a review article in a scientific journal, a patent makes a claim. The patent specification ends with a claim. a claim is worded as I claim or we claim, where the inventors claim something that they have invented as their own private property. So this part of making a claim with the objective of enforcing a legal right against third parties when the patent is granted is not there in a journal article published in a scientific journal, because you don't publish an article with the objective of stopping others from doing what you have done, whereas patents are documents which are filed with the objective of stopping others who are not willing to pay you a royalty or who don't enjoy your consent. Now, because these documents perform the function of stopping others, the documents have to clearly show what are the boundaries of your property. Patent is an intellectual property, so you need to demarcate the boundaries of your invention very clearly so that you achieve two things. One, you make it very clear that your property does not belong to the public domain. It's not a part of the public domain, because if it belonged to the public domain, then you are not entitled to a patent in the first place. Two, you make the boundaries so clear that others know where the limits are, so that people don't infringe it and people respect your right. So the way in which we achieve this is by drafting a claim. Now, patent law is an art of capturing technology in words in such a way that it performs a notice function to the world at large with regard to what you have invented and telling the world at large that this is a private property. So this is done through a document, what we call the complete specification. And once the complete specification is ready, it is filed using particular forms and by payment of particular the appropriate fees. We had already mentioned, if the complete specification is not ready, or you need to make a disclosure but a full disclosure of your invention, you can also file a provisional specification. The difference between a provisional specification and a complete specification is that the complete specification must have claims. The last part of the document where you make a claim with regard to your invention, what we call the claims, have to be there in a complete specification. In a provisional specification, you can file even without having claims.